By not making a will, the Fateh Singh family was in deep trouble. It was not even Fateh Singh's death anniversary yet when his children reached the court regarding the distribution of his property. After Fateh Singh's death, both his sons split the property among themselves. When his daughter Saloni asked for her share, then the scenario turned into a tiff-like situation.
This story is not just about Fateh Singh's family. There is a legal battle over property split among lakhs of families in India. According to PRS legislative research, more than 4.5 crore cases were pending in Indian courts till September 15, 2021. According to an estimate, 2/3 of these cases are related to real estate. It takes years to settle such cases.
Despite reforms at the government level, there are some questions about partition of property over which there has not been a clear picture even after decades. Some of the big questions on this are: how much right does a daughter have in her father's property? Does the daughter have a share in her grandfather's property? Can the daughter get her rights after marriage or not? The Hindu Succession Act 1956 was amended in the year 2005 to protect the interests of the daughter. Under this act, daughters have an equal share in the ancestral property. Whether the daughter is married, widowed, unmarried, or abandoned by her husband, she gets a share in the inherited property right from her birth. Here, the condition is that if her father was alive till September 9, 2005, in this situation, the daughter can get a share in the ancestral property. If the father passed away before September 9, 2005, then the daughter will not get any share in the ancestral property. However, the property purchased by the father himself is divided according to the will.
The Apex Court made it clear that even if the father died before September 9, 2005, the daughter would still have the same right on her ancestral property as the sons. If the father has acquired his property on his own, then it is the father's wish whether he wants to give his property to the daughter or not. But if the father dies without writing a will, the daughter can also take part in that property.
The Supreme Court has recently formed a new system regarding the rights of the daughter. Under this, if a person living in a joint family dies without writing a will, his daughter will be entitled to his property along with his sons. The daughter will be given priority in the property share over her father's brother's sons. Such an arrangement would also apply to the distribution of property before the enactment of the Hindu Succession Act 1956. Senior Advocate of Supreme Court Anil Kanwal says that a daughter has full right in an ancestral property, irrespective of the fact whether or not she is married, widowed, or divorced. However, daughter can get share in father's self-acquired property only if he wants to give it on his own will. If the father does not want to give his property share to the daughter, then she does not have a part in it. If the father dies before writing the will, the daughter can get a share in his property. Fateh Singh did not write a will. In such a situation, legally, Saloni will get a share in the property. Money9 suggests, make sure you prepare a property distribution will on time. Mention clearly about how much share is to be given to whom. Include daughter in the will to avoid family conflict. In most cases, brothers make their sisters sign a no objection certificate.